The topic for today is failed real estate transactions, and this is a webinar brought to you by Cowen Litigation, which is our law firm. So a bit about Cowen Litigation. We're a boutique litigation firm with offices in Toronto and Vaughan, and we serve Toronto, the GTA, and rest of Ontario. We have 2 lawyers and 3 support staff, and our roots go all the way back to 1903. So here's a letter from back in the day, 1903, when the firm was called Lennox, Cowen and Brown. And Frank, can people see when I use my pen tool? You see the pen tool, Frank?
I can see that. No, yeah, I can see the pencil. Yeah.
Okay, great. So Frank, by the way, is my Zoom technician, and moderator, if you're wondering who Frank is. And so moving on. So Cowen Litigation, we do real estate litigation and commercial litigation. And our cases have been featured in several respected publications, such as the Toronto Star, Thomson Reuters, and Mondac. And myself, the presenter, my name is Nick Tenev. I started my legal career in downtown Toronto on Bay Street. I have an engineering background. I'm a 2016 year of call, and I've been operating Cowen Litigation since 2019. I'm the principal and owner of the firm. And as I mentioned, we focus on real estate litigation and commercial litigation, which are also my focus as a lawyer. So the agenda for today is as follows. We're going to do a little introduction, which we just finished. We will look at the common types in which real estate transactions fail. Then we'll look at 4 cases, each one for around 10 minutes. And then we'll have a little sign off at the end, some final words, and then we'll have Q&A for 10-15 minutes. So it should take around an hour. We'll try to keep it under an hour, but it might go a bit over. Okay, so what are the common types in which real estate transactions fail? Well, there's 6 common ways. One is due to a condition. Second is due to late performance. So something is done too late, for example, delivering funds. Number 3 is repudiation, and we'll explain what that is later. Many of you probably or most already know. Number 4 is misrepresentation. Number 5, title defects, and 6, physical defects. Now, in this webinar, we will just cover the first 4 due to time constraints, but there will be another webinar for number 5 and 6 because those are also more complicated and nuanced topics, so they deserve more time. So we're just going to be covering the first 4 in this webinar. And so we'll be covering 1 case for each of them. And all the cases are recent cases, 2025 cases. They are Ontario cases. And although we'll be looking at specific cases, they will we'll be taking the principles from those cases, the lessons, and looking at how those principles apply to kind of the broader transactions and any kind of future transactions you might encounter. So we'll be looking at the broader principles as well. And the target audience for this webinar is real estate solicitors in Ontario. We do have a few non-lawyers in the audience, which is great, but the focus is for real estate solicitors. So when it comes to the Q&A, we will be prioritizing questions from solicitors because this webinar is for them. And the goal is for solicitors to stay current in the law, to know what's happening in the courts, and also to be able to better handle failed transactions, and plus to prevent transactions from failing in the future. So just to make you better equipped all around. And for the non-lawyers that are attending, just a little disclaimer, this is not legal advice. It's not to be relied on or acted on, this webinar. This webinar does not create a solicitor-client relationship, and Cowen Litigation and myself are not liable for any information in this webinar or how it's used, and always seek legal advice for your legal matters right away. And also for the Q&A, please use the Q&A chat box in Zoom. Don't use the message box. The message box is for any just general comments, technical issues, or feel free to message Frank, my moderator and technician, with any technical issues you might have. Okay? Okay, so let's proceed to the first case. So the first case is Yui versus Yan. It's a 2025 Court of Appeal decision, and it involves a lawyer approval condition. And I know what you might be thinking. These are simple conditions. You see them all the time. The APS is conditional on the approval of the buyer's or seller's lawyer. It seems like a simple condition, but as we will see, it can lead to litigation. I mean, this case was litigated all the way to the Court of Appeal. So let's take a look. And also, we'll obviously be looking at how the lessons from here apply to conditions in general. So in this case, we have an assignment agreement. So this is not a purchase and sale transaction. It's an assignment. And there is a lawyer approval condition that the APS is conditional on the approval of the assignee's lawyer within 17 banking days. So just to recap, the assignee is kind of like the buyer in an assignment. The assignor is kind of like the seller. And the condition is based, as you can see here in my third bullet point, on the solicitor's own and absolute opinion. And so what happened is within that 17-day period, the condition period, the real estate agent of the assignee sent a notice of termination on time. It's within that 17-day period to the assignor saying they're backing out, that the assignee is backing out. And the assignor had a problem with this termination notice. They did not accept it. They did not accept it as a termination notice and refused to return the deposit. So why was the assignor so upset? Because we have this message within the time period. So this is the email from the agent up here. It says, "I'm sorry, they have decided to back out. I'm sorry that we have wasted so much of your time. Thank you." So kind of a pretty general, vague email. And that's kind of why the assignor had a problem with it. The assignor's issue was that the email simply said the assignees are backing out. It didn't say anything about relying on the condition, that they met with their lawyer, or anything like that. And so the assignor suspected that there is an ulterior reason, that the assignees wanted to back out of the agreement for some other reason. And they were simply using this lawyer approval condition to as kind of a way to get out. But they weren't actually relying on it. They didn't actually, their lawyer actually probably didn't have a reason for them to back out. They were just simply trying to back out for other reasons. But the issue that the assignor has here is that they cannot prove this because they cannot access the lawyer's files, the lawyer's notes, and question the lawyer. So the assignor argued that there's no solicitor-client privilege. There is an implied waiver of solicitor-client privilege due to this condition, because essentially their argument is that how are they supposed to know what the lawyer said and that in fact the lawyer was not happy with the APS? There's no proof. So the assignees could be lying. So there's an implied waiver. That's their argument. And they want to know what the lawyer said because that will help them make their case. And so this is a big concern for solicitors because can the other side have access to your files as a solicitor in any situations like this? Can you be cross-examined and asked to explain what you discussed with your client? And so question the audience here, do you think the Court of Appeal waived solicitor-client privilege due to this condition? Did they side with the assignor to say, yes, you can have access to the lawyer's notes and the lawyer has to give you reasons? So what do you think, yes or no? Frank, if you can put up a poll. So Frank will put up polls throughout just to have you give your opinion. So I'll give you 10 seconds if you can please vote. I'll give a few more seconds. I see people are putting in answers, so I don't want to rush you. You have 5 more seconds. Okay, Frank, if you can stop the poll. All right, Frank, can everybody see the results? Well, I'll just explain the results.
Sorry.
So,
I'm sorry. They should be able to see them.
okay, I'll just explain the results.
Sorry.
So we have 32% saying yes and 68% saying no. So interesting, we have a split here. And let's look at what the court said. So first of all, it's important to note that the court accepted that the assignee met with their lawyer prior to the termination. So that's important, we'll see later. So they actually did meet with their lawyer before terminating. And so the court actually said that privilege is intact. So I guess no would be the right answer in my question. So privilege is intact, and they sided with the assignee. They said the lawyer does not have to provide the reasons. And speculation about the assignee's other motives are irrelevant. So the court really sided here with the assignee, and it just shows that the courts take solicitor-client privilege very seriously, and they also read these conditions very strictly because the court also said that if the assignor wanted the reasons, they should have put that in the condition. They could have put it's subject to the lawyer's approval, reasons to be provided. So that's how the court saw. They read the condition very strictly and protected solicitor-client privilege. And let's contrast that with another 2025 case regarding lawyer approval conditions. Again, these seem like simple conditions, but we can see now 2 cases in 2025 regarding lawyer approval conditions. So in this case, Bell versus Bisalian, unlike the Yui versus Yan case, there was a lawyer approval condition for the seller. So the seller could review the agreement with their lawyer and back out. And in this case, the seller never met with the lawyer prior to terminating. So that's very interesting here. And I must note that the condition was actually worded in a way which said that if no notice is provided by a certain date, the deal is dead. It's null and void. So it operated in a way where the seller actually does not have to give notice. It just says if the time period runs out, the deal is null and void. And that's what the seller thought. They thought, well, I don't have to meet with my lawyer. I just have to not give a notice. And then the deal is null and void, which, to be fair to me, kind of, might have a case there, but the judge did not side with them. So the judge said that although it's worded like that, that after a certain time period, if no notice is provided, the deal is null and void. The condition is a lawyer approval condition. So the seller in this Bell case has a duty to meet with their lawyer. They can't just not meet with their lawyer. And also in the Bell case, the seller admitted that they did have an ulterior motive. So he admitted that he changed his mind. On further thought, he believed the sale price was too low. He had a common law partner and she was not happy and told him, you're not selling that property. It's too low. The price is too low. So he admitted the ulterior motive and basically was using the lawyer condition to mask his ulterior motive, so to back out. And the court was not okay with that. So what is the lesson here for solicitors? The broader lesson that you can apply to any conditions, right? So it's very interesting that we saw these cases on solicitor approval conditions, but what about any condition? So number one, there's a duty of good faith. You must try to complete the contract as intended. You can't try to use these conditions kind of dishonestly to get out of the contract. And we can see that with the second case with Bell. He never met with his lawyer and there was another reason. So the court didn't like that. We also see that if the condition requires something, you must do it in order to rely on the condition. We see that in Yui versus Yan. They actually met with their lawyer and they didn't have to explain why they met with their lawyer. And, let's be honest, there might have been an ulterior motive, but the court didn't care. They just said there's a lawyer condition. You met with your lawyer, you can get out. Other reasons don't matter. Other reasons you might have to back out. But so your clients have to do that thing, right? Whether it's home inspection, seeking financing, due diligence, environmental testing, whatever it is, they have to do it in order to rely on that condition to back out. The other thing that's important is clear communication. So vague communication can invite litigation. And we see that in this case, the email from Yui Yan, we see from Yui versus Yan, the agent's email was very vague and that invited suspicion in litigation. What if the email was more straightforward? Maybe litigation would have been avoided altogether if the agent said something like, hey, we are relying on the lawyer condition. We met with a lawyer. They weren't happy with the APS. The APS is now null and void. And if you, as I mentioned previously, if your client, let's say you're the seller, wants those reasons, you have to put them into the condition. Now, practically speaking, I don't know if that anybody would agree to that. And even if you agree to it, you might get some vague reason and then, you're back to litigation. So I don't know if asking for reasons would really help here. Okay, and obviously solicitor-client privilege remains intact. That's the most important lesson. Okay, so that's the first case. Now let's move on to the second one. I'm just closing the poll we did. Okay, so the second case is Kaiven Creekside versus Logoteta. And this is a Superior Court decision regarding anticipatory breach and repudiation. And it involves the buyer not making deposit payments on time in terms of a new build purchase. So this case involves a pre-construction townhouse in Oakville, $3.3 million price tag, and the buyers had already paid $100,000 in deposits. However, they had missed two deposit payments, one in August and one in October 2022. But the seller, the builder here, had granted extensions. And the next payment was due on November 10th. So third payment is coming up. And the buyer tells the seller on November 4th that they will not be making that upcoming payment on November 10th. So they're giving them notice saying, hey, we're not going to make that November 10th payment. We're having some trouble with our financing. Apparently they have a house in the UK they're trying to sell and they're having trouble selling it. So they're giving notice that they will not be making that November 10th payment. But the seller on November 8th, so 2 days before the money is due, this time takes a harsh stance here and saying essentially no more extensions. This time you got to give me the money. And this is exactly what they said here in my first bullet. They said we will move to terminate the purchase agreement and all deposits paid shall be forfeited. And then later on, they also explained we're willing to consider in good faith reviving the transaction. So essentially, they're being very strict now. Give us the money or we will move to terminate. But they left the door open a little saying, if you do have the money in the future, we might consider reviving the deal. So what happened on November 10th, the deadline for this deposit payment? Well, that's the funny thing. Nothing happened. So the buyer did not make the payment. And the seller didn't say anything further. So nobody actually said anything. So absolutely nothing happened on November 10th. And so then we fast forward. Remember, this is 2022 November. We fast forward a few months to March 2023. And the seller sold this property to somebody else. The buyer, a little later in May, reaches out to the seller and inquires if this property is still available. And at this point, the seller is kind of scratching their head and saying, what do you mean? You breached the agreement. You never provided a deposit on November 10th. We terminated and we have the right to sell to somebody else. And the buyer goes, well, no, you have breached the agreement. The deal was still on. You can't just sell the house to somebody else. So the seller thought the deal was terminated based on what they said. The buyer's position was, no, it was never terminated. So another poll, who do you think was right? Was the deal dead? So the seller is saying the deal was dead, was terminated. The buyer is saying, no, the deal was not dead. So Frank, if you can put a yes or no poll, was the deal dead? Frank, can you put the poll? Hi, Frank, you're muted.
Sorry about that. I'm trying to get the poll up.
Oh, somebody's saying that they cannot see the presentation. They can only see me. Okay, so the poll is up. And while you guys put up your answers, somebody asked if this is 1 hour substantive. Yes, this is 1 hour substantive. And the presentation is being recorded. We will put it up for 30 days. I'll have the details at the end of the presentation. Okay, so we'll stop the voting. Frank, here, I think I can end the poll. Okay, if you can share the results, Frank. So was the deal dead was the question. So 60% said yes. 60% of you said yes. And 40% said no. All right, interesting, very interesting. So, and thanks for voting. So first of all, let's look at the law on repudiation and anticipatory breach, and then I'll have the answer for you. So repudiation occurs when one party shows by conduct or words an intention not to be bound by the contract. And anticipatory breach is just early repudiation before the obligation is due. So in this case, if on November 10th, the buyer said, I will not have the money today, that would have been repudiation. if they said it on November 4th, like they did, that is anticipatory breach because their obligation, the money, is not due yet. So they're telling the other side early that they will be breaching. So that's anticipatory breach, but it's just a form of repudiation because they're indicating they will not be bound. They intend not to be bound by the contract. And so repudiation gives the innocent party a choice of two options. Number one, to affirm the contract, which means to treat the contract like it is not terminated, like it's still going on, like it's still a live contract. So option one is to affirm, or option B is to disaffirm, to accept the termination. So this discharges the parties from any future obligations, and the contract is terminated. So again, repudiation, when somebody says they will not meet their obligations, the innocent party can affirm or disaffirm. So they can choose to terminate the contract or not to terminate. And so what do the courts say in this case? So the court said that there actually was no termination. So actually the audience thought the opposite way. 60% of you thought, yes, there was termination. But the court said that the wording that the seller used, that they will terminate, suggests more steps. So this is a very important case to show you how words really matter. Saying we will terminate, the court interpreted to mean there will be another step for us to terminate. We will, send you another email when we terminate. So it suggests more steps, the wording we will terminate. And the court said that the disaffirmation language was not clear. So remember, the seller, the innocent party, has to disaffirm or affirm. So in this case, disaffirming is terminating the contract, and they have to do so clearly and unequivocally, which they have not done here according to the court. And some other things the court considered are that the extension was given previously by the seller in August and October, and so it's not, the buyers maybe can expect another extension here in November. And the closing was 18 months away, so there was time for the defendant to cure the breach, to cure the default, to bring the money in. And the election of whether to disaffirm or affirm the contract, so whether to terminate or not, has to be done within a reasonable period of the repudiation. So that's key. So there's a window in which the innocent party has to terminate the contract, has to disaffirm or affirm. So you cannot do that months later, because we see in this case that later in the next year, in March or May, they did have that conversation where the seller said, hey, no, we terminated. But that's too late. That's months later. So there is a reasonable window in which you have to terminate. And what that reasonable window is, I mean, we can probably do a whole new webinar on that, but it has to be within a reasonable window. And obviously, it's good to do as soon as possible when you hear the other side is repudiating. And the court said in this case, by selling, the vendor, in this case, the builder, was now itself unable to perform because the deal was still on and they had sold the property. So actually the tables have turned. So a pretty funny case where the buyer was the one who couldn't come up with the money, and then tables turned and they won and walked away and got their deposit back. So in my opinion, a very interesting case. And the lesson for solicitors here is that anticipatory breach does not in itself terminate the contract, right? So you might have a transaction where the other side says, hey, we will not have the money. So you can't just advise your clients, well, the deal is dead, right? The deal is terminated. It's not terminated. Your client has to elect, has to choose to terminate. And you have to capture that, that language clearly in writing. So clearly and unequivocally, whether they want to affirm or disaffirm. And also in a timely manner, as we saw, on or around the time of repudiation. So don't let them sit for weeks or months. That might be too late. And talk to your client first if they want to do that. That's a serious conversation, whether they want to affirm or disaffirm. And repudiation, the language around repudiation, it's not always clear. So the other side might say, we might not have the money, or, can we do this if we can't close, right? So there might be kind of this vague language. And sometimes, with kind of that vague language, the courts have said that's not repudiation. So you want to be very careful and very sure that the other side, the language they use, is in fact repudiation. And obviously you can never be 100% sure, but you kind of want to be mindful in advising your clients that, you want to be careful and be confident the other side is in fact repudiating. Yeah, so we talked about that using clear language. Oh, this is just another lesson. If your client is the breaching party, you might want to stay silent, right? We saw in this case the buyer stayed silent and that reasonable period passed and the deal was still on. So sometimes, if you're the breaching party, you might want to stay quiet. But again, you have to have that discussion with your client. They might be pressing you, hey, what is happening here? Is it terminated or not terminated? And clients want clarity. They want black and white, but sometimes just kind of staying in the weeds actually might be beneficial to your client. Because if you seek that confirmation, the other side will say, well, yeah, you've breached, and we've terminated now. So sometimes you don't want to seek that clarification. Okay, the next case, moving on, is Adeniji versus Makbul. And this is a Superior Court decision regarding misrepresentation in an MLS listing. And in this case, the buyers, they refused to close. So this is a residential property in Woodstock, Ontario, with a $1.1 million price tag and a $50,000 deposit. The closing date is July 2022. And this was an unconditional offer, so no conditions. And the buyers relied simply on the MLS listing to make their offer, their unconditional offer. They never even viewed the property in person before making the offer. So I think this was around the time the market was very hot. And that's why you were seeing these kind of, in my opinion, wild things like unconditional offers and buying houses without seeing them. And the buyers in this case alleged that there was some inaccuracies in the MLS listing. So four inaccuracies in particular. So the MLS listing in some places indicated there are 4 bathrooms and another 3 bathrooms. So it had a mixed message there. Sometimes it said 4, sometimes 3. In reality, there were only 3 bathrooms in this place. The countertops were not quartz as advertised, and the exterior of the property was not fully brick. It was partly vinyl. And also, it was not a park-facing property as alleged in the MLS listing. And by the way, the seller did admit all these inaccuracies. They said these were inaccuracies. The MLS listing was incorrect. So that's not in dispute. These were inaccuracies in the MLS listing. And what happened is the buyers, they sought a price reduction of around $13,500. They amended the APS because of these inaccuracies, but then they still refused to close, saying like, hey, we know we amended, but these are misrepresentations. We feel it's not correct to close here. We can get out of the deal still. And so they refused to close. And so question to the audience, were the buyers entitled not to close in this situation? Again, these are the 4 misrepresentations. Frank, can you do another poll, please? Okay, we'll give a few more seconds. I see people are still entering answers. Okay, Frank, you can end the poll. Okay. So 46% said yes, and 54% said no. So 46% of you, roughly half between whether the buyers can refuse to close. So the court said no, they cannot refuse to close. And the reason for that is that, for example, for the bathrooms, the court felt that, not felt, but ruled that these were typing errors. And a reasonable person would have noticed that these are typing errors because sometimes the MLS listing said 4 bathrooms, in other places 3 bathrooms. So somebody reading this would realize, okay, there's some typo going on here. And a reasonable person would have inquired how many bathrooms there would be before putting in an offer. And even then, the court said the extra bathroom, this 4th bathroom that was not included, had a value of around $7,500 to the buyers. So when they were doing that price reduction, they valued that extra bathroom at only $7,500. So not a huge dollar amount compared to the $1.1 million price tag. And the other things, such as the quartz countertops, fully brick exterior, and park view, the court said these were minor and just aesthetic things, so not material. And the court also said that there's no evidence that these issues materially affected the financing, the value, or the buyer's ability to close. And the buyers themselves valued these things in total at around $13,500 because that's the price abatement that they agreed to. So that's 0.5% of the purchase price. The court also considered that the buyers were experienced and real estate agents. The buyers sought the price reduction and amended the APS, and that the buyers refusing to close was sought only a few days before closing, while they knew about these inaccuracies for months. So they were slow to act. So the court felt that was a factor to indicate that the buyers did not feel these inaccuracies were important. So why did the buyers fail? The court said not every inaccuracy or misrepresentation justifies rescission. Rescission means undoing the contract. It's different from termination. We'll talk about that another time. But not every inaccuracy or misrepresentation justifies rescission. The misrepresentation must be, number one, material to the contract, and number two, induces the other party to enter into the contract. So the court said you need those two factors to make the misrepresentation material and to allow the person to rescind. But what does that mean? What is a material misrepresentation? So the court further elaborated that it would be considered by a reasonable person to be relevant to the decision to enter the agreement in question. And also later on, the court said it would be substantial and goes to the root of contract. So super clear, right, guys? No, you totally know what material is now, right? No, pretty vague, pretty nebulous. And basically that's kind of one of the takeaways here for solicitors that as we saw with the poll that I did, it was 46% of you thinking that the buyers can get out, 54% thinking no. And the court gives this very kind of vague, nebulous definition of what material is in terms of material misrepresentation. There's also this other Supreme Court of Canada case that you can look at where they describe it in further detail. But essentially in this case, the court ruled that the buyers breached the APS by failing to close, and the sellers were entitled to the price difference between 1.1 million and what they sold the property at in the future to a different buyer, which was around 246,000 plus carrying costs. So that would be probably like mortgage, utilities, things like that. So the lesson for solicitors is that misrepresentations must be material plus induce the buyer to enter into the APS in order to justify rescission. And buyers must raise these inaccuracies or misrepresentations right away. You can't sit around. If you raise them faster, it looks better. And what is material in terms of a misrepresentation is not always clear cut. These are very fact-specific things, and judges decide them on a case-by-case basis. And they also take in many considerations, and we obviously cannot come up with an exhaustive list. That's beyond the scope of this webinar, and it's maybe impossible to come up with an exhaustive list, but we saw things like whether the buyers are experienced and things like that. So because it's a very fact-specific thing, and we've only seen one case, let's take a look at a few more cases. And one thing before we do that, I want to mention that in general, it's safer to close and sue for damages. So these inaccuracies, even if no price abatement was given, the buyers could have still sued for damages. So many times it's just safer to close and sue for damages than it is not closing, because you might have clients who go, hey, this property is 100 square feet less, or they promised they would include, I don't know, the hot tub, but they took the hot tub, I'm not closing. So in those situations, or, there's maybe a hole in the wall, like a big hole in the wall when they were moving. So unless it's something very, very big, and I realize that's not even black and white, but in general, it's safer to close and then sue for damages, because if you don't close and you're wrong, then you can be liable for a lot of money. We can see here the buyers were liable for around $250,000. So if your clients do not want to close, just make sure to tell them that that's very risky. What is material is very nebulous. It's not a clear-cut thing, and they could be liable for the price difference, carrying costs, litigation costs, and any other reasonable damages flowing from their breach. And make sure to explain to them, as I mentioned, that what is material in a misrepresentation is not a black or white thing. You might have to do research. You can tell them to speak with a litigation lawyer, and always put your advice in writing for these kind of serious things and get their decision in writing because, as some of you might know, clients tend to misremember things in the future when things don't go their way, right? They might be really fired up. We're not going to close. And then weeks or a year later, they might go, oh, we should have closed. And why didn't you advise me of this and that when we might have advised them of that, but it was verbal and they misremember things. Okay, let's look at a few more cases on misrepresentation. So the first one here is Isa versus Wilson. And in this case, the agent negligently misrepresented the size of the home. So the agent gave a few measurements, but they were between 2,000 and 2,500 square feet for the size of the home, when in fact it was 1,450 square feet. So a size difference between 27 and 42% roughly, based on which number you take that the agent provided. So was rescission allowed in this case? Frank, if you can please do a poll. Okay, we'll give a few more seconds. Okay, Frank, if you can stop the poll. Okay, so 89% of you said yes, rescission allowed, and you are correct. The court said this was a substantial difference. It's a first-time home buyer, so rescission is allowed. So correct. So let's take a look at the second one. So this is a 1984 case, but it's a court of appeal case, and it's a pretty famous case, Jorian Properties versus Zelen Rath. And in this case, the property was misrepresented as a fiveplex, so as a 5-unit rental property, when in fact it was a 3-unit rental property, so triplex. So the buyer's getting 3 units, not 5, and they discover this before closing. So they already have a firm agreement, but they discover before closing that it's a triplex, not a fiveplex. So 40% less units, and the buyer goes, "I'm not closing." So, Frank, another poll. Did the court allow rescission in this case? Yes or no? Okay, Frank, if you can stop the poll. Okay, so we have 86% saying yes, rescission was allowed, and 14% no, it was not allowed. So this is one of those shocking cases. So the court said no, rescission is not allowed. And this is the Court of Appeal, mind you. And the court said essentially that this is not a fundamental misrepresentation. This is a multi-unit rental building, and the buyer is still getting a multi-unit rental building. It's just they're getting less units. But they wanted a rental building, and they're getting one. And the buyer, in this case, according to the court, should have closed the transaction and then sued for damages. Now, there was a dissenting judge who did not agree, who said this is material and this is not right to make the buyer complete the transaction. But nonetheless, overall, the Court of Appeal judges decided that this is not a fundamental, not a material misrepresentation. So yeah, very surprising case. I probably agree with the dissenting judge here. If I was the buyer and I got 3 units instead of 5, I'd be pretty upset. If it was maybe you were buying 20 units and you're getting 19, I think that's a small difference, but 3 versus 5, in my opinion, is big. But nonetheless, it's a useful case to show us that our intuition and what we think is fair might not always match what a judge think is fair and what kind of angle they take on in these situations. Okay, last one. The lot was represented as 71 feet by 120 feet, so as a rectangle, but it was actually narrower at the back. So it kind of tapered off at the back, and it was only 44 feet at the back, so roughly 37% smaller at the back. So was rescission allowed in this case? Frank, if you can put that up. Okay, so Frank, if you can stop the poll. So in this case, 34% of you said yes, rescission was allowed, and 66% said no. So in this case, the court said no, rescission is not allowed. They said that this is not a material misrepresentation, and also this should have been apparent to anyone viewing the property. So if anybody went in person, they would see it was narrower at the back, because apparently the buyers in this case, they did go and see the property. And the judge felt, well, they should have seen it was narrower and investigated more before putting in an offer. So the lesson from these three additional cases is that we see these misrepresentations, whether they're material or not, is very fact specific, and the decisions can be unpredictable. And the judges also take into account many different factors, whether the buyer is experienced or a first-time home buyer, whether they should have been able to see the inaccuracy. And also there's other cases where the intention of the buyer also is taken into consideration, whether they were going to rezone or redevelop the property in some way. So judges just don't look at the percent difference. Your client might be trying to box you into kind of a numbers game where it's like, well, this is 10% smaller, my property. This case was 15% smaller. I should win. But there's other factors. So again, don't let your clients kind of box you into those black and white discussions, because obviously clients want black and white answers. They want clarity, but don't be quick to jump into kind of black and white answers, because we see from these cases it's not always a black and white intuitive analysis or outcome. Okay, so the last case we're going to take a look at here. We'll go through it quickly because we're almost out of time. I mean, we have 15 minutes, but there might be Q&A, and I have some final words at the end. So the last case is Korea versus Valstar. And this is a 2025 Court of Appeal decision regarding time is of the essence, those clauses you see in APSs. And this is a pretty famous case from 2025. And let's take a look. So it was a new build purchase in Oakville. And what happened is the APS required the closing funds by 5 p.m. on the closing date. And it said time is of the essence. Again, this is a new build. Time is of the essence. Have your money by 500. So the buyer told the vendor, the builder in this case, that they're struggling with their financing. Can we have a little more time? Can we have a 1-day extension, please? And the seller, not the nicest people, not the nicest guy, said no extensions. Give us the money at 500. And so the buyer is, scrambling, rushing, well, probably their lawyer. And you guys might have experienced this, right? Closing day, down the wire, you're rushing, scrambling. And so 4:52 p.m., the lawyer, the buyer's lawyer, wires the money, right before 5 p.m., but it arrives at 5:09 to the seller's lawyer. So 9 minutes late. And so at 5:01 p.m., so 1 minute after the deadline, the vendor terminated the APS, said the deal's dead. So I just kind of imagine them hovering over the send button with their email ready, and bam, sending that email, the deal is terminated. And they did say, but the nice guys they are, they said we will revive the deal for 100,000 plus HST, which the purchasers end up paying. So essentially, they said, hey, the deal is dead because we need the money by 501, but we can do a new deal for 100,000 plus HST more. So was the seller justified in terminating the APS? The builder, was the builder justified? So Frank, if you can please do a poll. Okay, great. Frank, you can stop the poll. So 35% of you said yes, and 65% said no. What did the Court of Appeal say? Let's see. So the Court of Appeal said the seller, the builder, is correct. So I know not the answer as solicitors that you want to hear, because you can probably see yourself in those situations, and maybe those situations have happened many times on deals. Um, but the seller is okay in this case. They're correct. So the court said that the APS clearly required closing by 500, and both lawyers, the buyer's lawyer and seller's lawyer, understood this deadline. The vendor was entitled to rely strictly on the time is of the essence clause. And the $100,000 revival fee was not a penalty, but a new contract. So I put revival fee in quotation marks because it was not a revival fee. It was a brand new contract. But the buyers argued, well, this is a penalty. It's the same deal. And we're just closing maybe, I don't know how much later it was. It was probably the next day or a few days later. I forget what it said in the case. But it's essentially the same deal, but they're paying $100,000 more. And they felt like this is a penalty for us being 9 minutes late. And they also argued economic duress because essentially they needed this house, they had all their money ready, and what are they supposed to do, right? And the judge said, no, it's not economic duress. This is not a penalty. So the court said, I see no bargain here to rewrite the party's bargain. So essentially, the court is saying, well, they put in this time of the essence clause. And I mean, I know maybe it doesn't sound fair. The builders have a lot of power here, but in putting in these clauses, but that's what the court said. That was the bargain. The party said time is of the essence, and that's what it means. And the Court of Appeals said, and they cited another case, they quoted this case, which said, while the outcome for the respondent was indeed harsh, it was not unconscionable or unfair. So again, they recognize this is very harsh, but the courts take these time is of the essence clauses very strictly, so there's no wiggle room. Essentially, I guess their philosophy is kind of for, they don't want to start getting into an argument of, what is late? Is it 1 minute late or 5 minutes? And are there other factors? What if your car broke down when you were delivering the money? So they just take it very strictly, treat it very strictly. And so it doesn't matter how late you are if there's a time of the essence clause. Late is late. There was also a case, I think in 2024, where somebody was 35 minutes late and same result. They were told, that's too late. But this case was just 9 minutes. And again, that's too late. So what if they were 1 minute late? Probably too late. Same thing. Late is late. Doesn't matter how late. And, to avoid this, as solicitors, you can try to do the financing ahead of time. I realize that's not always possible, but, you can try to do the financing, maybe a day before, just so you're not scrambling on the closing day. And in this case, yeah, the deposit would have been lost if the seller terminated, which they did, but they negotiated a new deal. So your client can try to negotiate a new deal so they save their deposit at least. Okay, so that's everything. We have 10 minutes left. I'll just have some final words here before we open it up to Q&A. So first of all, thank you everyone for attending. We really appreciate it. Our website is cowanlitigation.com. If you want to visit our website, learn more about us. Again, my name is Nick Tenev. It's been a pleasure doing this seminar, and thank you all for participating as well. That was really great. I hope you enjoyed it as well. And if you have any questions, reach out to us. You can reach us at info@cowanlitigation.com, and we're happy to help you or your clients. That's our phone number. And also, we offer a 15% referral fee according to the Law Society. And so if you have any litigation matters that you send our way, we're happy to pay that 15% referral fee. And we have a really great team here. We're experienced. We give practical advice. We try to get solutions, practical, efficient solutions for your clients. And we're also accessible. A common complaint that clients have is, I can't reach my lawyer. We're very accessible. We get things done. And I'm confident you and your clients will like working with us. And so what's next? Well, you can join our newsletter if you haven't done so. Just email us at info@cowanlitigation.com. So the newsletter will have recent cases, and we'll also feature other content. We have a YouTube channel where we analyze cases just like this. And so you'll get recent cases and useful content. Also, if you want to kind of have, if you might be wondering, well, Nick, thanks for your presentation, but there's could be many situations. What do I do? I personally find this book useful. I'm not affiliated with this book. They don't pay me anything. But I find this book useful. It's called The Termination and Rescission of Agreements. for the purchase and sale of land by Michael G. Pratt. So it covers many situations. So if it is the closing day, and you're hit with some weird situation and you got to figure things out, it's good to have some kind of resource there. And I find this book pretty useful. We also have a Facebook group. So please join. Go to Facebook and type in Ontario Real Estate Law Insights. So that's the website where we post everything, OntarioRealEstateLawInsights.com, all our real estate content. So the group is called Ontario Real Estate Law Insights for Real Estate Lawyers. And just type that and hit join. It's a private group, so you'll hit join and we'll check that you're a lawyer. So it's only for lawyers, it's a private community. If you're a non-lawyer attending this presentation, we are working on a separate group for non-lawyers, but this is just for lawyers. And you can ask questions, chat with us directly, ask questions about anything. You can answer other people's questions. We're going to post exclusive content. So if you're looking for these slides, we're going to post them in the Facebook group, and we'll also post a link to this recording for 30 days in the Facebook group. So if you want that content, please join. And you might say, well, Nick, I don't have Facebook, or I use my Facebook for personal use. You can make a professional profile using your work email and just join there on Facebook. So please write that down and join. We'd love to have you as part of our community. And also, you'll get a short survey. So if you can please fill that out, and I'll be sending out a gift card, 2 gift cards to 2 people, so 1 gift card each. If you complete the survey in the next 24 hours, just about how you enjoyed it, how we can improve, things like that. It's only 9 questions. It's super fast, and you get a $50 Starbucks gift card. Who doesn't like Starbucks, right? And the next seminar will be in March. That's a substantive seminar, so on the law, just like this. And again, the audience is real estate solicitors, but we do have an EDI webinar coming up, and it's accredited. So we got the accreditation from the Law Society, and it will be on this topic here. It's an EDI, so it's that EDI hour, and again, it's free, and it's by Dr. Janelle Abella. She's going to be talking about EDI stuff and tough conversations, and it's going to be a useful topic, I think. You can learn more about it in our newsletter. So that's where we're going to post all the information about upcoming webinars. So please watch out for that. I don't have a link yet, but if you're part of our newsletter, just check out the newsletter or post in our Facebook group or email us if you don't see anything. If like February 20th rolls around and you don't have anything yet for some reason, let us know. But it would be great if you join us for that. Again, it's a free hour. It's February. Things are probably slow for real estate. It's a good time to take care of that 1 hour of EDI. So that's the last slide I have. So again, thank you very much for attending. It's been a pleasure. And Frank, if you can remove the poll and just let's see if people have questions. Are there any questions? Let's see if you can put your questions in the Q&A. Okay, so I think we do have quite a few questions. Let me check what people are saying. 1 second. Let me see here. So one person, okay, let me just see here. Okay. I'm just reading the questions quickly to see how many we have. Okay, so I'll go through them one by one. So please put them in the Q&A box. I'll try to get through as many of them as I can. I'll stay after 1 o'clock as well. So, okay, will the presentation be shared? As I mentioned, yes, on the Facebook group. Does the fact that these misrepresentations have been discovered, does the fact that these misrepresentations will have been discovered if there was an inspection matters? So yeah, if you discover them during the inspection, if there's a condition, then obviously you can rely on that condition. Now, if there's no condition, whether you found them through an inspection or not, I mean, at the end, it's the same. It's the same thing. It's a misrepresentation. I can't think of a reason why how you found them matters, but I could be missing something, but I don't think it matters how you found them. The fact that you found them before closing matters if you want to refuse to close. And if you find them after closing, you can still have remedies. But usually the issue is if you find them after closing is that you cannot usually rescind the deal. The deal's already done. So the courts do not want to undo the deal if you've already completed the transaction and taken title. So usually, if the deal's already completed, you would just sue for damages. So somebody asked if the misrepresentation and induce if there is misrepresentation and inducement, but it could have been discovered if the lawyer conducted a thorough diligence check, who is liable, seller or purchaser's lawyer? Again, none of this is legal advice, but I would say the purchaser's lawyer. So if it was within the scope of what a lawyer does and they didn't do it, then the lawyer would be liable. The seller's lawyer, I don't think would be liable unless they had a hand in it, which is very rare. The lawyer doesn't usually misrepresent things. Usually they're handed the deal the way it is, right? You're handed the APS already filled out. You're handed the MLS listing, unless you were involved in drafting the APS. So if your client said, "Hey, this is a duplex," put down duplex lawyer on the APS. Then you're potentially liable as a seller's lawyer if you just take your client's word. You should warn your client like, "Hey, I have not verified this." Like you're taking the risk if you get sued. So you should get that in writing. If you're just taking your client's word for stuff like that, you should recommend, "Hey, we should check this out. Like, do you have any proof that this is a duplex, for example?" In the number one case, would you encourage clients to speak to litigation lawyer prior to proceeding with the rescission of the contract? So let me just see the first case again. Yes, I always recommend clients speak with a litigation lawyer. Obviously, if there's litigation about to happen or a risk, it's always a good thing. I mean, you can advise the client as well on your opinion, but you can recommend a litigation lawyer, and I recommend that obviously because litigation lawyers might have seen more situations, and it also probably protects you. In what I mean by that is sometimes clients, when they don't get the answer they want, they're not happy. It's like going to the doctor and the doctor telling you there's something wrong with you. You're not going to be happy. Um, so clients might start questioning you or being unhappy. But if they go hear it from another lawyer as well, then they kind of realize that you're right and it's just the way the law is. So I always recommend a second opinion from a litigation lawyer if litigation is about to happen. And the earlier the better. I get that question too as well. Like, when should I engage a lawyer or a litigation lawyer? It's like right away, because the more you wait, I don't know what's going to happen and what risks you're taking. Dorian is very surprising. Yes, indeed. Yes, very famous case. Dorian and Ali, isn't it on the buyer or their solicitor to ensure that they can notice these things on the inspection, zoning, survey review, or off-title searches? Um, well, if there's no condition, then um, they did notice. So for example, Jorian, let's say the fiveplex, right? So you don't have to have a condition on due diligence. If the seller tells you this is a fiveplex and you sign an unconditional offer, they've promised the fiveplex and you're just now completing the deal. You're not required to put a condition on due diligence. And in Jorian, maybe they did do the due diligence. Well, they did something to discover that it was a triplex, right? So whether you want to call it due diligence or whatever, it doesn't matter. They discovered that it is a triplex. And so what happens is the question becomes, can you get out of the deal? So to answer this question, obviously it's good practice to have a condition on due diligence, but you're not required to. So that's kind of the issue here. So I guess the takeaway from this question, good question, the takeaway is, put conditions, because otherwise you have to, plead that you have to plead that there's a material misrepresentation to get out of the deal. So the lesson is, put conditions if you can. Otherwise, if you discover it, but there's no condition, you're kind of in a messy situation arguing it's a material misrepresentation. Okay. Somebody said, "I really hate this case." I think that's Jorian. um, okay, so we're at 1:02 p.m., by the way, guys. So for those of you that are taking off, thank you very much for attending. Um, I'll stick around to answer the remaining questions. I realize some of you are taking off, but I really appreciate you attending, and I do have a few more minutes, so I'll go through all the questions. There's not a ton. And if you have to run, you have questions, put them in the Facebook group. Okay, so I'll stick around to answer the remaining questions here. All right, so let's see here. In a private sale and for which financing condition are waived, and then the bank reached out to the seller's lawyer, who then refused to respond. What are buyer's recourse as the bank cannot proceed with the final proof of the mortgage? So Ryan's question is about a financing condition and the bank reaching out to the seller's lawyer. So Ryan, good question. It goes back to the duty of good faith. So that's kind of what I mean is that these cases, they have broader principles that apply to transactions in general. So there's a duty of good faith. So if somebody can do something, small here to keep the transaction going, I think the courts would probably say they should have done that, right? So if the bank wants to know what's the relationship, and there's no good reason for the seller not to give that information, I think they need to give it. Otherwise, they could be liable because essentially that duty of good faith is to kind of, it's kind of the oil that helps the gears turn, right? There could be a lot of little bumps and issues like that. And the court's like, hey guys, just try to get the deal done, try to be reasonable people. And so I think in that situation, there's an obligation to kind of, help out and get the deal done. Would the court review whether the lawyer took too long? Um, I mean, what would happen? So somebody's asking, would the court review whether the lawyer took too long? For example, if the lawyer took 3 extra hours to wire out. I mean, in that case, your client might sue you, unfortunately, because they'll go, well, like lawyer, like you took too long, so the seller is suing me, or I lost this money, I lost my deposit, but why did you take so long? I'm not saying they would be, they would succeed. I'm just saying they might. So, but yeah, so that's kind of what I see there. But basically, um, the court wouldn't say, okay, so no, you have to complete the transaction because the buyer's lawyer was too slow. The court would probably say, seller, you're correct in terminating the APS. Buyer, too bad, you lost a bunch of money. Go after your lawyer. That's your problem. That's your lawyer. If there is a claim there, again, I'm not saying there is a claim if a lawyer takes 3 hours, but um, assuming the lawyer's at fault, then the client would have to go after the lawyer. Will I be receiving a copy of the presentation? Like I said, we'll put it in the Facebook group. Same with the slides. And Shari is part of my team. She's helping me with this webinar and the CPDs. So we will have a list of all upcoming CPDs. Like I said, the next one is coming up in February 25th. I'll just share the Facebook group again so you guys can look at something while I talk. How can we join the newsletter group? Just email me for now or join the Facebook group and we can help you out there. Facebook group name is here. What are some things a seller can do potentially to repudiate a contract? For example, if the APS signed with a rent-to-own provision, but the landlord comes onto the property, force all tenants to leave, and affects the buyer's business so much that they can't close, can the seller be deemed to have repudiated the contract? Well, let's define repudiation again. It means you intend not to be bound by the contract. So if you did something, for example, got rid of the tenants when in fact there were supposed to be tenants, then you're potentially repudiating the contract. Now it has to be, material. So, it can't be like a minor thing, right? For example, hey, you won't have the coffee table on closing that you're supposed to have. Minor stuff. If it's not material, if it's not a condition. So in general, if it's not material, if it's not a condition, then you cannot get out of the contract. But if it's something deeper, then yeah, the seller can repudiate like that, of course. Yeah. Another form of repudiation is asking for new things, like, hey, I want an extra $50,000 or I want this extra thing. So a party to a contract asking for more stuff they're not entitled to and refusing to close because of that is also an example of repudiation. A buyer is purchasing the new build and expecting there is an occupancy period. It turns out that there's no occupancy period and the deal goes to final closing directly. The buyer cannot complete the transaction because they cannot arrange a mortgaging. Kindly requested the seller to sign a mutual release and agreed to forfeit all deposit, but the seller refused to sign a mutual release. Now, what the buyer can do to protect themselves. Turns out there's not. So a question here, it's kind of long, but essentially, if something bad goes in a transaction and you're asking how can your client protect themselves, you want to many times, again, not legal advice, not specific to your situation, but in general, you want to capture in writing what's happened and what your position is. Hey, you guys have not um, done the occupancy closing, or you've not done whatever, and that's why we are not closing or we're refusing to close. So sometimes you want to just capture in writing what your position is with the other side to put yourself in a better place in case the matter goes to litigation. It's clear what your client's position was. Can you give a couple examples of what a material misrep would could be? Well, we had the case with the square footage, right? So the square footage where the agent said it was 2,000 to 2,500 square feet, instead it was 1,450 square feet. So that was a material misrepresentation. Okay, so those are all the questions. Again, big thanks for attending this webinar. Thank you very much for attending, and let's stay in touch. You can join the Facebook group, like I mentioned, in our newsletter. And that's it for today. Thank you so much. Bye for now.